afternoon, everyone. Good afternoon, everyone. The first thing I have to tell you is that the seminar was yesterday and you missed it all, except this is April Fool's Day. So I just thought I'd start that out. I see a few familiar faces and names. That's good. I see that I'm also outnumbered by females, as I usually am in court. Most of my hearings, I'm the only male. Sometimes, obviously, the parents' attorneys, there are males. I think I'd start out with a little bit of maybe it's a story or a joke, but there were two men on a boat way out in the lake, and they were lost, and they saw a man on the shore, and they yelled out to the man, "Can you tell us where we're at?" And the man yelled back and said, "You're on a boat." And the one looked at the other and said that information was to the point and useless. Hopefully I will provide you with some useful information. You can ask questions. I'll try to do the best I can in asking and answering them. If you can return to the first slide.
Sorry, just hold on one second.
I gave them the responsibility to do it because
And I'm super slow, sorry. Okay, there we go. All right.
Okay, so if you could turn to the next slide. This is what I hope to discuss with you today. Number one, the differences between an LGAL and a GAL. The program went out and said the role of the GAL. What I'm going to be talking about is the role of the LGAL, which are two different things. I'm going to be talking about the Michigan statutes that the legislature has created regarding the lawyer guardian ad litem, the Michigan court rules regarding the lawyer guardian ad litem, to whom does the lawyer guardian ad litem report, visitation requirements for the LGAL and the best interest representation. Are there county policies regarding the LGAL, communication with the lawyer guardian ad litem, and foster parent and the lawyer guardian ad litem relationship? Next slide, please. Well, the first thing we have to do is that there's a big difference between a lawyer guardian ad litem and a guardian ad litem. You see that I underline the word lawyer. The lawyer guardian ad litem represents both the child's legal and best interest in child welfare cases. And there's a reason that the statute called them lawyer guardian ad litem, because they are also, as I've indicated, they're representing the child's legal interest, which means that at a hearing, at a trial, the lawyer guardian ad litem gets to ask questions. The lawyer guardian ad litem can interrogate witnesses. The lawyer guardian makes recommendations to the court. The Michigan statute and court rules state lawyer guardian ad litem specifically. You will not see GAL. A GAL is basically, and when we say GAL, it's a guardian ad litem, is basically appointed in probate and custody cases. So if someone has filed for a guardianship in probate court, the court will appoint a guardian ad litem to meet with the individual to see if they consent to the guardianship and find out what their thoughts are. And in custody cases where there's a dispute over the custody of the children, many courts will appoint a guardian ad litem to again meet with the child or children, to work with the two parents to see if they can work out custody issues. So the lawyer guardian ad litem is specific to our child welfare cases. Next slide. All right, so the powers and the duties of a lawyer guardian ad litem are found in the statutes and in the court rules. The statutes are created by the legislature. So I'm also going to be referring to, you have handouts, and it's the first handout. It's this is the statute, MCL 712A.7D, 17D. And it lists all of the powers and duties of a lawyer guardian ad litem. Number one, the duty is to the child and not to the court. I once had a judge make the statement, "You're my lawyer guardian ad litem." And I said, "I'm not your guardian ad litem. I'm the child's lawyer guardian ad litem. And I don't report to the court, or my duty is to the child." Now, I do obviously report to the court, my visits with the children, what's going on with the children and all that, but I don't legally report to the court. I report to myself and to the child. What are the obligations of the attorney-client privilege? That's important. That's why we are called lawyer guardian ad litems, so that no one is entitled to know what my discussions were with the children. No different than if I have a private client in my private practice where I represent an ex-employee who believes that he's been discriminated against. No one can compel me or the client to tell anyone what we've spoken about. The same thing is true here. No one can compel me to disclose what I've discussed with the children. And that's why, for all the foster parents here, that's why a lawyer guardian ad litem meets with the children individually, in private. Because if the lawyer guardian ad litem meets with the children in front of you, the privilege is waived. And I always make it a point when I visit the child at home, or even on Zoom now, I meet with them in private. I ask the foster parent, "Could you please leave?" They all do. They understand it. It's very, very serious that client attorney privilege stays in place. Determining the facts of a case by conducting independent investigation. A lawyer guardian ad litem is obligated to investigate on their own. That means talking to teachers if necessary, talking to social workers, talking to doctors, to get an independent investigation other than just relying upon what the social worker says. So that's a very important role of the lawyer guardian ad litem. Number 4, to meet and observe the child and assess needs and wishes at certain times. I'm going to be going through what the statute says, how often a lawyer guardian ad litem is required to meet with a child. I sometimes go beyond that. Sometimes I do what we call unannounced visits. I know a lot of foster parents don't like that, but I have learned as a lawyer guardian ad litem that sometimes I learn a whole lot more when I haven't announced that I'm coming. I know that it's an infringement upon the foster parent. I don't do it a lot, but sometimes I do it because I have a sixth sense. I think, well, I better check up on this one, and I don't want to pre-warn them. I want to see what's going on without announcing. Is it mean? It's not mean. It's my job, and everybody else who is a lawyer guardian ad litem's job, to find out what's really going on with a child. The lawyer guardian ad litem is required to file all necessary legal pleadings. It could be a motion. It could be what we call a legal brief, where we try to explain to the judge or the referee what the law is and what we believe they should do regarding a specific matter. Attend all hearings. The lawyer guardian ad litem is required to be at all hearings. Now, there are times when the lawyer guardian ad litem can't make the hearing. The statute and the court rule allows a lawyer guardian ad litem to get a substitute. But before they can get a substitute to stand in, they must get the approval of the referee or the judge, whoever the hearing officer is, and they must provide sufficient detail to the person who's going to be substituting, and they must indicate that they've seen the child. They can't ask for a substitute if they haven't seen the child and tell the substitute what their thoughts are. Make a determination regarding the child's best interest. That could be expanding visits for parents. It could be making a best interest hearing determination at the best interest hearing. Next slide. The lawyer guardian ad litem is required to monitor case plans. So the lawyer guardian ad litem is required to make sure that the services that the agency said they were going to provide for the children are being done. So that if the agency plan and their requirement is to provide therapy services for the child, I have to make sure that that's being done. Well, that can be by a couple of means: get the reports from the therapist, talk to the therapist. So the lawyer guardian ad litem has a lot of massive obligations and responsibilities. Promote cooperative resolution. Sometimes it gets very, very heated between the parents, the prosecutor, the prosecutor or the attorney general, and the workers. And if the lawyer guardian ad litem can sort of work as a work on conciliation and help people sort of cooperate a little bit more than make it a fight, that can also be done. Request authorization to pursue issues of child's behalf that do not arise specifically from an appointment, i.e. going to IEPs at schools when the kids have special needs and they have a 504 plan or an IEP of some kind. This one is the one that, at least in Oakland County, there isn't, in my opinion, a sufficient amount done. Participate in training in early childhood adolescent development. I don't know how much training there is for lawyer guardian ad litems in Wayne County or Macomb or Washtenaw or Livingston. That probably needs to be strengthened in almost every county. We are not trained or educated in childhood and adolescent development unless before you became a lawyer, before we became a lawyer, you were trained in that. The lawyer guardian ad litem can never be compelled to be called as a witness, and they can't be questioned about what they think, what they saw, what they heard, what their discussions were with the children. They can never be called as a witness. And my file, or every other lawyer guardian ad litem file, is non-discoverable. It's our file, it's mine. You can't look at it. It's just private. Now, I want to say one thing about a lawyer guardian ad litem and what I don't do. I never, ever, ever say the word adoption when I start meeting with foster parents when it's a temporary wardship petition. If the plan and the goal is reunification, I never mention that word because that isn't the goal. And if you have lawyer guardian ad litems who start talking about adoption when it's a temporary wardship, I think they're making an error. That's not their role to be talking about that at that time. Now, if it's a temporary wardship and the year has gone by and the parent hasn't sufficiently complied with their parent agency treatment plan, and it may be looking like there's going to be a change in plan and adoption is in the mix, then I may start talking to the foster parents. Are you interested in adopting the child? Because that becomes relevant. But I never ever discuss it. And if a foster parent raises the issue with me at the beginning, I tell them we're not discussing that because it's not on the table. Well, now we get to the court rules. Now the court rules are made by the Michigan Supreme Court. Okay, it's not the legislature. The Supreme Court has court rules regarding procedure. And the first one is MCR, or Michigan Court Rule 3.915, which is the assistant of attorney. And you'll see that in your package as well. I've made copies of all of these court rules, and the slide sort of summarizes what the court rule says. 1, the court must appoint a lawyer guardian ad litem in a child protective cases. It's not discretionary. The court must appoint a lawyer guardian ad litem in all child protection cases. At each hearing, the court must inquire if the lawyer guardian ad litem has met or had contact with the child. You're going to see, I know there's some, in a couple of the slides, talking about what if the lawyer guardian ad litem doesn't see the child. Well, we're going to talk about that because that clearly is a violation of their statutory requirements, and it could require a replacement of a lawyer guardian ad litem. If the lawyer guardian ad litem has not met or had contact with the child, the court shall require the lawyer guardian ad litem to state on the record the reasons for not doing so. Well, things happen. The lawyer guardian ad litem gets sick, the children get sick, the foster parents get sick, and the lawyer guardian ad litem just hasn't had the opportunity to see the children. Now, every lawyer guardian ad litem is different. Every foster parent is different. Some lawyer guardian ad litem will wait until the day before the hearing to come and see the child. That's not the best practice, because there may be the possibility that you won't be able to see the child. I try to do it within the week of the hearing so that I get the most present situation and the condition of the child. What a lot of referees and judges will do, if the lawyer guardian ad litem has not had the opportunity to contact the child, they will put in an order: you shall meet the child within a week, so that you're not waiting for another 90 days when the next review hearing is. So sometimes things happen. I mean, we have no control over people getting sick, so we have to, or a big snowstorm or something like that. So, but they are required to make contact with the child before the hearings. Next slide. All right, the lawyer guardian, this is Michigan Court Rule 3.965, and this talks about the preliminary hearing. And what I've done is I've taken the provisions regarding the lawyer guardian ad litem only. There's more to that court rule than what I put on the screen there. You'll see it in the written document. The lawyer guardian ad litem must be present to represent the child at the preliminary hearing. The preliminary hearing is the first legal proceeding in a child welfare case. The Department of Health and Human Services has filed, and CPS has filed a petition. It is either a petition for temporary wardship, or it is an initial petition for permanent custody. The first hearing that has to take place is the preliminary hearing, and it's supposed to take place within 24 hours after the petition is filed. At the preliminary hearing, there are the assistant prosecutor in Oakland County or the attorney general in Wayne County. I believe I'm not sure if it's the assistant prosecutor in Livingston or attorney general. I think it's the assistant prosecutor, and I think it's the assistant prosecutor in Macomb County. That is when the decision is made whether or not the petition is going to be authorized. And the parties can, what we call, request testimony from the worker, or we can waive testimony, which means we won't take any testimony, and the referee, based upon the petition, will decide whether or not it's going to be authorized and then moved on to the next hearing, which would be a pretrial. And if questions are being asked, then the lawyer guardian ad litem can clearly and obviously ask questions. And I will tell you that I probably 90% of the time I request testimony, because just reading a petition doesn't mean anything to me unless I hear some more detail from the worker to find out who said what did you see, what did you hear, what documents do you have. So the lawyer guardian ad litem clearly gets to ask questions at that hearing. Next slide. All right, the next court rule, MCR 3.966, other placement review hearings. The lawyer guardian ad litem can make recommendations regarding the best interest of the child in petitions to review placement decisions by the supervising agency. So the LGAL can say, yeah, we want a change in placement. We want to obviously change it from the present foster home to a relative placement, or remove the child from the relative placement to a foster home, depending upon what's going on in the foster home. And the LGAL gets to make recommendations. The court doesn't have to accept any recommendation made by a lawyer guardian ad litem. I will tell you that most judges and referees rely pretty strongly on the lawyer guardian ad litem, because they are, and we are, the lawyer for the children. And that's what this case is all about. You will always find in child welfare cases, the name of the case is in re, the name of the child or children. It's not in re, the name of the parent. It's not in re, the name of the judge. in re the name of the referee, in re the name of any of the lawyers. The children are a party to the case, and that's who we're there for, obviously. Even if, even when I represent parents, I mean, I always have in the back of my head, what are we going to do to help the child? I mean, anyone who's been a parent and has a child, we all know that we're obligated to at least, deal with what might be best for the children. So next slide. Now we have a trial, and there can be two different trials. The first trial is what we call a trial for jurisdiction. If a parent wants to have a trial to determine whether or not the court is even going to assume jurisdiction. And what does assuming jurisdiction mean? It means that if the court does assume jurisdiction, it can order the parents to do A, B, C, D, F, G, whatever. It can also order certain services for the children. So the parents may say, you know what? I don't think the court should even get involved in my life. I want to have a trial. The trial can be done by a referee, a judge, or a jury. I just did a trial last week in Oakland County where I represented the mother. And the issue was whether or not the court was going to take jurisdiction over her children. The jury determined that the court could have jurisdiction. At the conclusion of all the testimony, the lawyer guardian ad litem may make a recommendation to the judge or referee or to the jury regarding whether one or more, well, not in this case, there's no jury on whether or not one or more of the statutory grounds for the court to terminate parental rights have been proven. When there is a trial in front of a jury, the jury can only decide whether or not the court is going to take jurisdiction. No jury ever decides whether or not parental rights are going to be terminated. That's up to either the referee or the judge, whoever is going to be the one hearing the case. Again, after all of the testimony is in, the lawyer guardian ad litem may make a recommendation to the judge or referee whether or not he or she believes that the prosecutor or the attorney general has proven the statutory grounds to terminate parental rights. At the conclusion of all testimony, the lawyer guardian may make recommendations to the judge or referee whether or not it is in the best interest of the child to terminate parental rights. So there are really three separate kinds of hearings if the action is to terminate a parent's parental rights. The first hearing is what we call the jurisdiction hearing, whether or not the court is even going to assume jurisdiction. The next hearing is what they call a statutory grounds hearing to determine whether or not there are statutory grounds to terminate the parental rights. And that part of the hearing is geared to the parents. What do the parents have done and what haven't they done? The best interest hearing, everything focuses to the child. What is in the best interest of the child? And there are certain factors that our courts have said the court can look at to determine what is in the best interest of the child. Is it in the best interest to terminate or not terminate? And what the judge will look at or referee will look at is, can the parent provide stability, permanence? Is there any domestic abuse in the family? The other thing that they can look at is, can the parent provide better than the foster parent? That's the only time where the court can look at whether or not the foster parent can provide better care, more stability, more permanence than the parent. Okay, so, and we get all kinds of reports. We hear all kinds of testimony as to whether or not what's in the best interest of the children. Now, the lawyer guardian ad litem is obligated to meet with the children and discuss with them what they think or what they want. Now, the lawyer has to use some of their own, what we call best judgment. While the child might say, I love my mom and I don't want her rights terminated. A lot of it depends how old the children are. If a 6-year-old said that to me as opposed to a 15-year-old, it makes a big difference. Okay. So you have to every case is different. And you should know that any child who reaches the age of 14 in Michigan can object to an adoption. I don't know how they came up with the age 14. They just dragged it out of the sky because, I mean, we all know as parents, we all know as foster parents, there are some very, very, very mature 14-year-olds. We also know that there are some very, very, very immature 14-year-olds. So the lawyer guardian ad litem has to take that into consideration. But the law says a 14-year-old can object to an adoption. Next slide. All right, the reviews are normally every 90 days. They can be shorter. I've on many cases where we will have a review hearing, and because there's a lot of things going on and a lot of things that have to be done within a very short time, the referee or the judge may say, I want to come in early. I want to come in next month. And the lawyers look at their calendars, and that's the hardest thing, I think, for a referee and a judge is scheduling the next hearing. Because if you've got a lawyer for a parent, the father, a lawyer for the mom, and you've got the lawyer guardian ad litem, and you have the assistant prosecutor or the attorney general, their calendars all have to be available and they have to make themselves available. So sometimes it takes a little time to get the next hearing scheduled because everybody's busy. I mean, everybody has their own practices and other cases. So, and some lawyer guardian ad litems practice in both Oakland and Wayne or Macomb. So, and we'll talk a little bit about that, the difference of the counties, although I have not practiced. I only practiced one time in the Wayne County where I got retained to represent a mom in Wayne County. So, but I'll do the best that I can based upon my discussions with those lawyer guardian ad litem, excuse me, who work in Wayne County. Next slide. All right, the next time that the lawyer guardian ad litem is required to attend the annual permanency planning hearing during the continuation of foster care. The permanency planning hearing, by its term, annual, means it shall not exceed 12 months. So hypothetically, let's assume the court has already taken jurisdiction, and today is what we call the disposition. This is when the parents are told what they're going to need to do to get their kids back. They have to sign the parent agency treatment plan, and they now will have approximately within a year to substantially comply with the parent agency treatment plan. But that doesn't mean that they won't get their kids back sooner. I've had cases where the parents have gotten their kids back in 5 months, 6 months, 3 months. Depends on the circumstances, obviously. But the law says if they haven't substantially complied within a year, then the court can change the plan and they can change it to termination. Again, every case is different and every circumstance is different and each parent is different and how much they have succeeded. And a lot has to do on the agency because they also, the referee or the judge, has to make a finding that the agency has made reasonable efforts to allow for the reunification. I had a case this week where the referee said the agency has not made reasonable efforts. People are creating barriers for the mom, okay? And it happened to be created by the foster parent. And the referee was not happy. The U.S. foster parents are not supposed to be creating barriers for reunification. If the plan is reunification, everybody should be working towards that plan. At a permanency planning hearing, you are able to participate. And the referee or the judge will probably want to hear from you as foster parents. Number one, how are you doing? How are the kids doing? You may be called as a witness at a trial. I'm in the middle of a case right now where the foster parent has the kids. I represent the father, and she has been questioned on how the kid's doing. The kids have special needs, what's happening with the kids. So you may be called as a witness, which means you have to take an oath to tell the truth. And you can be questioned by the assistant prosecutor or the attorney general, the lawyer for the father, the lawyer of the mother, and the lawyer guardian ad litem. Next slide. Am I going to be answering questions at the end? Because I know people have been asking it, but so why don't we just wait, because I think it'll be easier if I can answer the questions at the end. Is that okay for everybody?
Yeah, that's what I was thinking. 'Cause a lot
Okay,
of them
thank
are answered
Okay,
already,
yeah.
so.
Okay. Now, who is in charge of the lawyer guardian ad litem? Meaning, who supervises them and how can they be reported for their conduct? As I've already indicated, the LGAL is an independent attorney in each case. Now, in Oakland County, they are appointed by the county assignment clerk. We have in Oakland County a juvenile assignment clerk, and she has a list of all the lawyers who serve as either lawyer guardian ad litems or attorneys for parents. And in Oakland County, they make the appointment. I didn't put it on the slide, but in reviewing them, in Wayne County, there are what they call pods, groups of attorneys, and I think there are maybe 4 or 5 of a group that could be about 3 or 4 attorneys, and they contract with those groups to provide the services as lawyer guardian ad litems. Now, because they have a contract, they can put certain requirements in the contract. One of the terms of the contract that says the lawyer guardian ad litem shall see the child 3 times a month or 3 times a week. Obviously, when someone writes a contract, they can put whatever terms they want to put into it and require the lawyer guardian ad litem to do something more than what the statute says or what the court rule says. There are no real policies that I'm aware of in Oakland County, because everything that a lawyer guardian ad litem is supposed to do is in the statute, and we're required to follow the statute. So we are appointed by the county assignment clerk. We report and make recommendations to the court. Like I said, in Oakland County, the Attorney Appointment Committee exists to review any issues with the lawyer guardian ad litem and other appointed attorneys. Now, I don't know what they have in Wayne County or Macomb or Livingston. In Oakland County, we always call it the double secret probation committee. If you remember Animal House, that they were put on double secret probation. It's a committee that meets. No one really knows who's on the committee. And they meet to review any issues involving any lawyer guardian ad litem or any of the appointed attorneys. Do they show up? Are they prepared? Those kinds of things. And the committee can remove attorneys from the list. They can bring the attorney in and talk to that attorney. And if the attorney happens to be a lawyer guardian ad litem, they get complaints from the referees, the judges. They could get them, and then it filters into them or from the assignment clerk, and they make the appropriate action. The misconduct can be reported to the judge or referee at a hearing. If you happen to be at a hearing, you're the foster parent, and the lawyer guardian ad litem hasn't come to see your client or made contact either by Zoom or some other way for the last 6 months, the judge and referee has to know that, because they are not doing their statutory duty. You can raise the issue with the agency worker, because that's the person who you have direct contact with. So you say to the agency worker, the lawyer guardian ad litem hasn't shown up here, hasn't called, hasn't seen the kids, hasn't spoken to the kids. What do? What will normally happen is the agency worker will then report it to the assistant prosecutor or the attorney general or to the DHHS supervisor who has overall care of the child. They report to DHHS because DHHS has contracts with the foster care agencies. So there are ways to raise issues about the lawyer guardian ad litem. Next slide. I hope that doesn't happen often, but unfortunately, I am a realist and I know that it may. How many times is the legal or the lawyer guardian supposed to visit the children who are in foster care? And again, this is from that statute, which is the first slide that I gave you. Before the pretrial hearing. So the petition has been authorized by the referee, and it's now going to be sent to a referee or a judge for a pretrial. The lawyer guardian ad litem is obligated to make contact and see and speak to the child if they are able to speak. If the child is an infant, you obviously can't speak to the child, but you're obligated to see the home. You're obligated to see the child. And at the pretrial, you are obligated to report to the referee or judge your findings and what's going on with the children. Before the initial disposition, if held more than 91 days after the petition has been authorized. Now, again, let's assume today is the day that the petition gets authorized. We've had the preliminary hearing and the referee or judge believes there's sufficient evidence to authorize the petition. You'll have the pretrial probably within 2 to 3 weeks. At the pretrial, the parent can plead, can say, yes, I'm going to give the court, I'm going to give the court jurisdiction. The disposition will then normally take another 4 weeks because the agency worker has to prepare a parent agency treatment plan for the parent, for the child, and for you folks as foster care parents, because you have to sign the parent agency treatment plan as well as to what your obligations are. No corporal punishment, none of the stuff that, that you are going to be required to do. So if it's before the initial disposition, if held more than 91 days after the petition, more cases or not, you don't have to do it before the initial petition disposition because you've already done it before the pretrial. Next one is before dispositional review hearing. As I stated previously, the dispositional review hearings are about 90 days apart. The referee will say, or the judge, all right, get your books out. Let's come back if today is the first, if today is the dispositional hearing where the parent signs the parent agency treatment plan, the referee will be looking about 90 days from now to set a dispositional hearing. Then there'll be a dispositional hearing every 90 days after that to determine how is the parent doing with their parent agency treatment plan and how are the children doing. Then we get to the permanency planning hearing, and that's where we talked about 12 months. It could be before 12 months, it could be a little after 12 months. So that's another time that the lawyer guardian ad litem is required to see the child or children. Then we get to the step that obviously parents don't like, but now we've already had a decision that their parental rights are going to be terminated, okay? So we have what was known as a permanency or post-termination review hearing. That's the time now that the adoption workers get involved, and they have to come up with what's the plan, what is required to get adoption done. In Oakland County, we sort of call it the rocket docket because these hearings take more often. I mean, we meet more than just every 90 days. It's usually like 30 or 45 days because the goal is adoption and everybody needs to know how that's going. And the longer that goes on, we all know that it's harder for the kids. I mean, that's why we're working for permanence, and that's why we need to do that quickly. Now, at least once during the pendency of a supplemental petition. All right, the court has determined that there should be a termination of rights petition filed. The agency, whether it be DHHS or the foster care agency, whoever is obligated to file the supplemental petition, files the supplemental petition, And we may not have a trial for a while. Again, because everybody, you have to schedule it. You have to give enough time for everybody to get prepared. So again, lawyer guardian ad litem has to meet at least once while that petition is still pending. The last one, at other times as ordered by the court, adjourned or continued hearings do not require additional visits unless directed by the court. So let's again hypothetically say we have a hearing today. And for whatever reason, someone isn't ready to make a report and the judge says, I'm not going through with this hearing without having all those reports. So you've already seen the child before that hearing, and the judge or referee schedules the next hearing for 20 days. The lawyer guardian ad litem is not required to see the child. That doesn't mean they can't, just means they're not required to. And as a note, the visit or the contact doesn't have to be in the home each time. It can be at school. The lawyer guardian ad litem can show up at school and talk to the kids. Now, I personally don't like going to the school to see the kids for a couple of reasons. They're supposed to be in school, in the classroom. They're not supposed to be meeting with lawyers. That's my opinion. Other lawyer guardian ad litems may see it differently. The other thing that I have found over the many years is that if they are called out of the classroom, they get a stigma. Kids are going, where are you going? Why are you leaving the classroom? They don't need that. There's enough that goes on in the schools, unfortunately, where kids get bullied and all the other stuff, that they don't need this added on to it. I will meet kids at a restaurant. I'll meet kids if they're doing a sibling visit. If there are kids, if there are 3 kids in the family and 2 kids are in one foster home and the other kid is in another foster home and they're having their monthly visit, I'll kill two birds with one stone. I'll go visit all the kids. And I want to see I also want to see, I may go to a parental visit because I want to see for my own 2 eyes as the lawyer guardian ad litem, how the parent and the child are reacting with one another. And is the parent using good techniques on ways to, divert the attention of the child if the child is getting a little out of hand? Are the parents using what they're supposed to be learning in parenting classes? So a lawyer guardian ad litem can visit the children in the home. They can visit them at sibling visits at the agency, out in the community. And now with Zoom, I have been doing the visits by Zoom. A couple reasons. I'm 72 and they say that I'm vulnerable. I never thought of myself as vulnerable until the pandemic, because they started calling anyone over 65 as vulnerable. So I've made it a course not to see kids in person, because even though I've been boosted and all that, I don't want to harm a child, and I don't want the child to harm me in any way. So I've been doing it by Zoom. They've been working out fine. I meet with the kids, I talk to them. Are they better? Is Zoom better than personal visits? Probably not. But in all the cases, I've seen the home at least once, because in all my cases, a lot of it was done. I got appointed before the pandemic. So, but it's just to say that the LGAL doesn't have to do the visit in the home each time. Next slide, please. All right. I know this question comes up because Jackie gave me these questions, so I knew that this is some of the stuff that you guys are concerned about. How can a lawyer guardian ad litem stand before the court and state the best interest of a child when he or she has never met with the children? My short and obvious answer is they can't. There's no way that a lawyer guardian ad litem can get up in court and tell the judge what they believe is in the best interest of that child if they haven't seen him or spoken to him at any time. So if they do, they are clearly violating their statutory obligation They are clearly violating any contractual obligation that they may have in Wayne County, and that can't continue. So that needs to be reported. So it's either through the agency worker, or if you are in attendance by Zoom or in person in court, that can't happen. That's got to stop immediately. If they get up and start making representations, then they're committing a fraud on the court. And that is very, very serious. So my simple answer is there's no way that they can talk about the best interest without ever meeting the child or and talking to them. Next slide. Where do you go to find out what your county requires in regards to the LGL visitation in your home? Are there policies? Well, again, all of the lawyer guardian ad litem's requirements are stated in the Michigan statute and the court rules that I have provided to you. That's the Bible. That's what we are required to do as a lawyer guardian ad litem. My guess is you won't find any county written policies. Again, I haven't been an LGL in Wayne County or Livingston or Macomb, so I don't want to say that you won't find them. I have not seen them particularly in Oakland County, because everybody knows that what you're required to do is by the statute and by the court rule. Now in Wayne County, because they have a contract with these group of attorneys or pods, PODS, they may have some requirements or they may have some policies in their contract that says this is what the lawyer guardian ad litem is required to do. I have not seen any of those contracts, so I can't speak firsthand whether or not such requirements are in their policies or contract, but that's where a county could put them. And you may want to ask, you're probably not going to be shown the actual contract, because the contracts are private between the county and those groups of attorneys, and there's obviously how much they're going to get paid and all that. So, but you can find out if there are any special policies. Next slide, please. Should you contact the lawyer guardian ad litem and introduce yourself and invite him or her to your home? As I've indicated, once the lawyer guardian ad litem is appointed at the preliminary hearing, he or she should contact the foster parent to make an appointment to meet with the children. In Oakland County, at the preliminary hearing, the contact information is provided by the foster care worker to the lawyer guardian ad litem, so that the lawyer guardian ad litem can make contact. If the lawyer guardian ad litem does not make an appointment or make contact with you, you should contact the foster care worker so that he or she knows that for some reason, the lawyer guardian ad litem is not contacting you to make an appointment to come see the kids for the first time. So that's very, very important. And at that meeting, the lawyer guardian ad litem is going to try to establish a relationship with the kids and with you as the foster parents, because that's one of the people that you're going to be in contact with a lot during these proceedings is the lawyer guardian ad litem, because of their statutory duty to come and see the kids, to find out how the kids are doing, to find out if there's any issues that need any immediate attention. If there's an issue that needs an immediate attention, the lawyer guardian ad litem can call the court and say, I want an emergency hearing. I want an emergency hearing now. Okay. I had a case years ago where I was the lawyer guardian ad litem, and unfortunately it made the press. I got calls from Washington, New York, the New York Times. I, as the lawyer guardian ad litem, the 4 kids were with their grandparents. And there had been a petition to terminate the parental rights of the parents who were serious drug abusers. And I'm not going to ask for your opinion one way or another, because I know that there are differing opinions on this, but the kids had not received their immunization for measles. The parents didn't believe in getting their kids immunized against measles. I took it upon myself as the lawyer guardian ad litem to file a motion with the court to require that the foster parents, the grandparents, get the kids immunized. This was at a time when there were kids that were getting sick in school because they weren't immunized. Well, I got calls from all kinds of people all over the country. I didn't talk to the press. I make that a practice not to do so. But my concern was for the kids. I really didn't care about what the parents thought. I really didn't care what the foster parents thought. I had a very strong belief that the parental rights of the parents were going to get terminated because of their very serious drug usage. Now, the judge probably did a very wise thing politically. She didn't render a decision and she didn't make an order until the parents' rights were terminated. And then after the parental rights were terminated, she said, yeah, get these kids immunized. I don't fault the judge for whatever decision he or she made. But sometimes the lawyer guardian ad litem has to make some unpopular decisions and some unpopular motions. But that's the role that we are as the lawyer guardian ad litem. And I will tell you, just as an aside, as a lawyer guardian ad litem, I have to go to sleep at night with a very good belief that the kids are safe wherever they're at, whether it be in relative foster care or unrelated foster care. And if I'm not comfortable and I don't think I can fall asleep, then I'm going to be making some recommendations to do a change. I don't want to be the one that gets a call, something's happened to the kid. And that's just not something I want to do as a lawyer guardian ad litem. So if the lawyer guardian ad litem doesn't make an appointment, I would contact the foster worker. Next slide, please. Should you give the lawyer guardian ad litem a report on the children in regards to the adjustment in your home? Absolutely. You are the eyes and ears of the lawyer guardian ad litem. We rely upon you as the foster parents and for those foster care workers to tell us what's going on. How are the kids adjusting? Are there sibling fights going on? Are there issues in school? Are the kids having a reaction to the medication that they're on? Again, we're only obligated to see the kid every 90 days, and you have to remember your case and the kids that you have is not our only case. So we have other kids that we have to see and other kids that we have to deal with, and we have to deal with the parents that we have as clients. So please tell us what is going on, good or bad. If the child has gotten an award in school, let us know. That's important, okay? So that we can tell the judge, you know, the child got this great award in school. And if you tell us, we can also call the child and congratulate them ourselves. I mean, we try to be, you know, obviously as friendly with the children as we can be and to make positive contact with them. So please report the good and the bad. Okay, next slide, please. What foster parent should not do or should do as a foster parent in regards to contact with the LGAL? What type of contact is preferred? Well, every lawyer guardian ad litem is different. Some lawyer guardian ad litem like to use email. Some like to text. Some foster parents like to text or use email. Some would rather do it by phone. Some would rather do it by Zoom. You know, who knew of Zoom before January of 2020? If I would have known about Zoom in December of 2019, I would have invested in their stock, because after the pandemic started, everybody was doing by Zoom. And all of us who are, let me say, in the older age, between, let's say, 60 and over, who are probably not as technically savvy as the kids themselves and the workers, we had to learn how to do Zoom. We had to get a camera. We had to know how to do the link. We had to know how to do the login information. But it's going to stay here for a while, everybody. In my discussions with the referees and the judges and everybody else, Zoom is going to stay around even after the pandemic, and we're still in it, but after it decreases even more because of the convenience and because of the one thing that we have found because of Zoom is that everyone appears, everyone shows up. Where prior to Zoom, if a hearing was in, downtown Detroit or in Pontiac or wherever, and there was snow and the parent can't get a cab, they can't get a bus, they can't get an Uber, they didn't show up, or they showed up 30 minutes late. Well, that doesn't help anybody in these hearings. With Zoom, they pretty much show up. And that is very, very important. So the only place that Zoom, you can't do a Zoom, obviously, is you can't do a Zoom on a jury trial. That has to be in person, okay? But in regular, like what we call garden variety review hearings, they're going to be by Zoom. And I think you're going to find Lawyer Guardian Land using Zoom to see the kids. You contact the LGAL if you believe there are issues regarding the children. And I say here, better safe than sorry. To me, I don't, if a foster parent calls me and they say, I really have this concern, I'm not sure it's a concern, I don't care, call me. We'll talk about it, we'll figure it out. But if you don't make the call and then something happens, then that's when obviously, things get changed a little bit. So that's my philosophy. I don't tell any lawyer guardian ad litem other than myself what to do. That's the way they do it. That's the way they do it. But I would rather hear it than say, well, I really didn't know if I should bother you. The only time I don't answer my phone is if I'm in court, because we can't. The court doesn't want us answering the phones while we're in court. So pretty much, I try to return a call or return a text or, return an email. I use all of those, quite frankly, whatever is best for the foster parent. I want to use whatever is best for the foster parent. If they're not into the internet and to email, then many of them know how to text and they'd rather do text, which is fine with me. I don't care. But whatever is best for you as the foster parent is what I do. Next slide. All right, I have to tell a very tragic real life case. This case also made the news. I was not the lawyer guardian ad litem, but there were issues regarding the foster parent, and there were issues regarding the foster care agency. This is a case where I represented the father, and he had several children, but there was one in particular who was in foster care, and the child was on the autistic spectrum. So there were a lot of issues with the child. It was not very communicative. His attention span, there were issues because of the autistic spectrum. Well, the child and other children in the home, because the foster parent had other children, were taken to the park on July 4th. This park happened to be in Davison. The foster parents, for whatever reason, we never really found out for sure, were not watching while they were all sitting in the pavilion that was located at the park. And the child became lost. He was about 13, but the cognitive level of probably a 4-year-old or a 3-year-old because of the autism. The agency did not notify the lawyer guardian ad litem. I did, as the parent's attorney, after my client called me. Matter of fact, I happened to be out of town. It was the 4th of July vacation. I remember I was in Columbus. And the parent called me frantic, obviously. And they said they lost my child. They don't know where he's at. I immediately got on the phone with the lawyer guardian ad litem because she happens to be a good friend of mine, and they all are. We communicate all the time. So I told her, I said, your client has become lost at this park. Thousands of people began looking for this child over 2 or 3 days. And unfortunately, on the 5th day, the child was found deceased in the lake near the pavilion. Very tragic, very, very tragic. Why do I tell this story? Because there's a couple of things. The foster parent had had a prior substantiated complaint for improper supervision with another child. When I heard that and I learned that, I blew a gasket. That child should have never been placed in that foster home to begin with. If they had a substantiated complaint of improper supervision, how do you place a child there? Was the question. And they gave no good answer. The next problem is the agency didn't call the lawyer guardian ad litem until I made the call, and I made it that night. That they should have immediately gotten a hold of the lawyer guardian ad litem and said, you know what, we have a serious issue going on here. So there was a lot of blame to spread around. And unfortunately, when there's this kind of tragic result, there always seems to be a lot of blame to go around. And it was very, very troublesome to me. I took it personally. I just said, wait a minute, what is wrong with our system? We place an autistic child in a home where there's been a substantiated complaint for improper supervision. They take the child to a park. They're not watching the child. You know, if the child maybe was, 8 or 9 and not on the autistic spectrum, but a child on the autistic spectrum and you're not watching them continuously, that's criminal in my opinion. But so that's a tragic case, and they don't happen, hopefully, and thankfully, they don't happen very often. But I do remember a case in Oakland County. I was not involved in the case in any way, where this particular lawyer guardian ad litem had not seen the child in foster care as much as he should have, and the foster child died in the foster home. Well, the judge was not a happy camper. There's one thing about judges. They are political because they run for office, and they don't like to see their name on the front page of something that's happened bad. They don't want to see their name linked to a case where a child has died in foster care or has been severely injured in foster care. So that's why the lawyer guardian ad litem is required to see the children so often. And I know it's not happening in any of the homes who are on the Zoom today. But I had a case where I just, we all as adults have a sixth sense sometimes, you don't know where it came from. But I had a hunch that there was some stuff going wrong in a foster home where they were elderly, and I don't, I'm an elder, but they were older foster parents. I think they were maybe in their late 60s or 70s, and the kids were young. And there's just something that it just didn't feel right. And then I did an unannounced visit, and the child told me that he was being physically hit with a belt, at which point we removed the kids from that home. So that's why the lawyer guardian ad litem is a pest. And I know many of us are considered pests to the foster parents. But all I can tell you is that's our legal obligation. And while you may not like the intrusion, that's what happens in these cases. So if you have a lawyer guardian ad litem who is making your life miserable because they want to see the kids as much as they want to see the kids, I guess all I can tell you is bear with it, because that's what they're going to do. So that's sort of my sermon. I think the next slide says questions, I think. So I know that the questions have been coming in. I don't know how the moderators want to handle this, but I'll let you deal with that and tell me how you want me to answer, or how, how you want to deal with these.
Okay, well, I could just start with the last question that came in. It says, we have a termination trial in April. What happens if the referee doesn't grant termination?
Okay, so if it's an initial petition to terminate, or if it's a supplemental petition to terminate, and the referee determines that the prosecutor or the attorney general hasn't proven their case, then the petition gets converted to what we call a temporary wardship. It is no longer a petition to terminate. It reverts back to, or converts to, a temporary wardship. And then the agency is obligated to provide services or more services to the parent. Okay. And it may be, whatever the judge or referee feels the agency needs to do. The referee has made the determination, you know what? Either I don't think that the statutory grounds were met to terminate, or I don't believe that it's in the best interest. A lot of times that's the last stage in a termination trial. So the referee could say, you know what? You haven't proven to me that it's in the best interest to terminate, and I want the parents to get more services. If that means wraparound services, or family reunification services, or more parenting classes, whatever. It is no longer a termination petition. So that happens. That's the job of the lawyers for the parents. That's what we have a legal obligation to. If I represent a parent, my job is to advocate on their behalf to determine and try to get the referee or judge not to terminate. That's my job. Next question.
Yep, our next question is just, could you repeat the difference between the LGAL and a GAL?
Okay, if you could go back to the, I think it would be the third slide. Let's try that. Okay. I guess the most important difference is, you see, I underlined the word lawyer. And the lawyer guardian ad litem is the only place where you'll see it is in child protection cases. You won't see it in probate. You won't see it in child custody cases. It is particular to the child welfare cases. And it is called a lawyer guardian ad litem because the lawyer not only represents the child's legal interest, but their best interest. And those are two different things. It could be that what his legal interests are different than his best interests. Now, there are cases where there may be 2 or 3 foster children, all from the same family. And the best interest of one of the children may be different than the best interest of the other 2 children. Or they may determine that there's a conflict of interest, that the one child is doing something to the other child and it's causing a problem. If that's the case, a lawyer guardian ad litem can ask the court to appoint a second lawyer guardian ad litem for the other children. And that has happened, where if the one lawyer guardian ad litem says, you know what, there's a conflict between the kids, we maybe need another lawyer guardian ad litem. A guardian ad litem is not able to ask questions, can't interrogate witnesses, but the lawyer guardian ad litem is. That's the important word is lawyer, because once you put the lawyer in front of it, they now act as their lawyer, which means asking questions, filing legal motions, and those kinds of things. So that's the major, I guess that's the major difference. Have I answered the question, or if not, please let me know.
Okay, it's not really a question, but somebody just said that they really wish the previous LGALs in their county cared for kids as much as you do. Hopefully the new ones that they have appointed will be better. So, well,
again, I don't know what to tell you there. I've been doing this now for 44 years, and I used to, when I first started doing this stuff and newer attorneys were coming in, I always tried to, I tried to give him what I thought was reasonable advice, but everybody makes their own decisions. Everybody practices differently. But like I said, my major goal is to go to sleep at night knowing that the kids that I represent are safe. That's my major goal, quite frankly, and to represent their legal interests, which means do what I can at trial to make sure what I think is the best decision for them. Sometimes I don't recommend termination, and many times I've not, either because I don't think it's in their best interest, either because I don't think that the prosecutor has met their statutory burden. There are lawyer guardian ad litems who will do and say whatever the prosecutor says. That ain't me. I will never do it just because what a prosecutor says. If I think they're right, I'll agree with them. But I'm not a I don't know what the term is. I'm not a washboard. I'm not someone that just says, yeah, do whatever the prosecutor does. That isn't me. So, but I've heard lawyer guardian ad litems who do that. They don't do very much. They don't ask questions, and they'll say, I agree with the prosecutor. Well, you really, in my opinion, that lawyer guardian ad litem didn't need to be there because they really weren't doing their job. But that's just my opinion. I keep it to myself. I store it away and remember it for the next time. Next question.
Okay, so there's another question about, is there any oversight or investigation by the state of Michigan of the relationship between referees, judges, lawyers in Wayne County?
In which county?
Wayne County.
Yeah, again, I don't know. Now, there is oversight. First of all, I'll go through each first. There is oversight for lawyers, okay? We are all members of the State Bar of Michigan, okay? They have what is known as the State Bar Grievance Commission. A client or anyone can submit a complaint. It's anonymous, or however the Grievance Commission deals with it. And the Grievance Commission will do an investigation to determine whether or not the lawyer has violated any of our canons of responsibility. We have what is known as the Michigan Rules of Professional Conduct for lawyers. And there are things laid out there that we can and cannot do. And if the Grievance Commission believes that a lawyer has violated those canons, they can take all kinds of actions. They can reprimand, they can suspend, they can revoke the license, they can require continuing legal education. They can do all kinds of things. So that's the oversight for the lawyers. For the judges, there is the Michigan Judicial Tenure Commission. The judges report to that commission. And people can make complaints about judges. And a lot of the complaints that are made about judges, at least the ones that I've reviewed and read and seen, is their how they treat people in the courtroom, yelling and screaming and demeaning and all that kind of stuff. There are also lawyers who are also judges who are no longer judges for some more unseemly things, for having a sexual relationship with a lawyer who's on the case. That happened it was the judge who had a relationship with a police officer who was on the case. That happened in Livingston County. There have been judges who have been reprimanded for the way they talk to the children, to the way they talk to the parents, to the way, if the foster parents are on there, and the way they talk to the foster parents. The judges have a canon of obligations too. So let's see, all right, now the referees report to judges. Referees are lawyers, but they are not judges. They are appointed by the county judges. And the referees report to the judges, and the referees do not make orders. The referees can only recommend to a judge, and then the judge has to sign the order. So the judges in your county They learn things about their referees, probably word of mouth, or if somebody has, made some kind of written complaint. Everybody in the system is accountable to somebody, some agency, some entity. Now, the foster care workers and the DHS workers are accountable to their bosses, the state, and they too are licensed. So they are potentially possible where their license get revoked. So everybody is accountable to somebody. I don't think that, that people can just do whatever they want. But the system isn't quick. So if somebody files a complaint against a lawyer or against a judge, you're probably not going to get any knowledge or anything dispositive. Could be a year, could be 2 years. They act at their own speed. You have no control over that. So was that question answered appropriately or enough?
Yeah. All right, so we have another question. It's a family that's been in a termination hearing that's been initiated since July of 2020. It's still going on because parents are allowed to demand in-person hearings, and there is constantly one party or another who is not able to show. They've only heard half a day so far and are not done. Is there any regulation to finally force everyone to show up and complete the hearings so the kids can get permanent planning after 3.5 years in care?
Excellent question. And I'm involved in some of those myself, okay? And unfortunately, the pandemic changed everything on how these cases are heard. The statutory obligation is to try to get these done, obviously, as quickly as possible. Now, some judges and some referees are requiring in-person hearings for when there's a termination petition going on. And even if it's not a jury, even if it's just the judge or referee who's making the decision. I can tell you in Oakland County, I would say 98, 97% of termination trials that are done in front of a referee or a judge are done by Zoom. They made the decision to do it by Zoom. Why? Because if the party doesn't show up by Zoom, then yes, the referee sometimes or the judge will just say, we're going on. They got notice of the hearing and they didn't show up. That's a little different when you're requiring someone to show up in person and the car broke down or the cab didn't come or the bus was late or something like that. I personally, from a lawyer perspective, I would much rather have, when you have a termination trial going on, to have it in person for a couple of reasons. It's difficult in trials when you have exhibits and you have documents and you want to show a document to a witness. Let's assume I've asked a question, okay? And the worker testifies differently than what she wrote in a report. And I want to do what is known as impeach that witness. I want to show that her credibility is not all that good. Well, I'm not there to hand the document to them, okay? The other thing in a Zoom, I don't know what else they got on the table. I mean, at trial, we know what they have in front of them and what they don't have in front of them. Now, the referee always says, or the judge always says, you're not to have any documents in front of you. You're not to have anybody else in the room. But there's no guarantee. I don't know, many of you, I'm sure, have seen, because it's been on YouTube for so long. There was a hearing on the west side of the state, and it was a violation of a personal protection order case. So on the Zoom, you had the judge, you had the prosecutor, you had the woman who filed for the personal protection order, claiming that her boyfriend was, threatening her and physically hitting her and all that. And then you had what they call the respondent, the man who was alleged to have violated the PPO. So people were talking and and all of a sudden the prosecutor raised her hand and said to the judge, Judge, I think they're in the same room. Well, unbeknownst to the gentleman, the judge directed the sheriff to go to the house. And lo and behold, he was there. And the judge said, I mean, it's sort of funny. I mean, it's so absurd, but the judge said he'd been a judge for 30 years and he was never a witness to an actual violation of a PPO before. But he actually witnessed it because the guy was in the room. And the Zoom is good for a lot of things. It has its limitations though. But I guess to get back to the meeting, I go off sometimes in tangents. These cases are taking longer. And a lot of it has to do with the scheduling of the lawyers and the referee, because the referee or judge has 60 other cases. The lawyers have other cases, and they've got to be there to do it. And if they can't be there, they got to pick a different date. And sometimes those dates are out within your mind, and I can clearly understand that. And I think that's why the question was so on point and so excellent, because I understand from your perspective that why is it taking so long? It's just a nature of the beast right now because of what's happened with the pandemic. And see, some judges say, you're not coming in. We're not doing it in person because I can't social distance. And in the jury trial that I had last week, we were required to wear masks unless we were speaking. And I told the judge at the beginning, I said, Judge, I have hearing aids. I said, there's no way I'm going to hear anybody through that mask. So she agreed, and at least the people who were speaking could take off the mask. So things have changed, and we have no control over it. And so I don't know if I've answered the question to the questioner's satisfaction. I guess it's what we call a fact of life. I don't know how to answer it any differently, because we're all living it. We'd all like these cases to finish sooner. I do as a lawyer, because every night after the one day, I have to write my notes down again to remember what the witness said, because I may not see that witness again for another 4 or 5 weeks. Where normally in a trial, I'm going to see him the next day. My memory is better. So it's not good for really anybody. And the worst thing it is for the kids, because it's just more time that they're out there wondering, when is this thing going to get done? When am I either going to get returned to my parents? When am I going to get adopted? When is there going to be a guardianship? So that's, there's a lot. I wrote it as a note, there's different things than just adoption and reunification. There are such things as a juvenile guardianship, where you as the foster parent get subsidized to become the juvenile guardian, as opposed to if you adopt the children, you don't get subsidized by anybody. Every case is different. And in some cases, a juvenile guardianship may be better for the foster parents and for the children, depending upon the age of the kids, than adoption. Because every case is different. And so there's lots of things that can happen with kids once they're in foster care. So, next question.
Actually, our next one is going to be about guardianship. So if during the foster care case, the permanency goal is changed to adoption, will a GAL then be assigned or not until the guardianship is granted?
Okay, first of all, it's not the GAL, it's the LGAL.
Yeah.
And so let me refresh my recollection. There's been a petition to terminate.
Change to guardianship. The
Again,
permanency goal.
All right, now, again, there are 2 types of guardianship. There's what we call the juvenile guardianship under the child protection law, and there's called an EPIC guardianship, that's EPIC, which is under the general probate code. Now, a general guardianship is not a favored plan for very young children. Because the child's going to be in a guardianship for, who knows, 15 years, that's not, or 16 years, that's not a very good goal. And a regular guardianship is not as permanent as a juvenile guardian. In a regular guardianship, the parent can file a petition to terminate the guardianship almost every year. Where in a juvenile guardianship, the rules are a whole lot different. And what's required to terminate the juvenile guardianship is much more stringent. It's harder to do. The lawyer guardian ad litem, once there's a juvenile guardianship involved, the lawyer guardian ad litem is out of the case. They're not involved in the juvenile guardianship. The regular guardianship, if the court wants to keep the lawyer guardian ad litem, they can. You know, the judge or the referee can keep a lawyer guardian ad litem on whatever case they want to keep them on. That's their decision what to do. But again, that decision is made at a permanency planning hearing or after there's termination, and now you're at a post termination, and that's when the plan is sort of discussed. Is it going to be adoption? Is it going to be a juvenile guardianship? Is it going to be a guardianship? Those kinds of things. So, or what we call APLA, another alternative plan. If the child is 16 or 17, you know, we may say the plan is that they're going to be in a residential facility, or there may be an adult foster care. A lot of it depends upon the age of the child. You know, to do an adoption of a child of 16 or 15. Again, this is a general statement, right? And it's clearly not in every case. Generally, I have learned, and I think it's a fair, that foster parents want to adopt younger children. Okay, they don't want to adopt 17-year-olds because that child's already been on their own or had another parent for so long, and you aren't going to be doing a whole lot of parenting because at 18 they can go wherever they want to go. They're now an adult. So if the termination is determined, then there's all kinds of plans that can take place regarding the children or children.
I think we only have 2 more questions. So is the LGAL required to visit kids who are placed in a home with a parent that is not a respondent on the petition?
Yes. Answer to that is yes. The LGAL is required to visit and make contact with the child regardless of where they're at, even if they're in the home of a non-respondent parent. Yeah, I mean, that's just the answer to that is clearly yes. There is no exception for the child being placed in the home of a non-respondent parent.
Okay, and I think our last question is going to be, what if you have a 16-year-old who has been in the system for a long time, but you feel that the child might be better with the birth family at this point in their life? Birth mother's rights were terminated due to failure to protect when the children were very young.
Okay, and is the questioner assuming that the foster parent has adopted the 16-year-old?
You know what, I'm not sure, but
All right, I'll try to answer it if I can. If the foster parent has adopted, you're the parent. You don't have to say that you're the adoptive parent. When somebody adopts somebody, you are the parent. You are the legal parent. I get murked when people try to make that distinction. You are the parent. And the parent makes the decision on who the child sees and who the child has contact with. You don't make the decision if you're not the parent, though, or the juvenile guardian, as to can the child live with the parent, even though, you know, the alleged neglect and abuse took place years ago. But if the questioner is assuming that you have become the parent, then you as the parent make the decision on who the kids see. And let's be real, okay? I'm a realist, okay? I mean, I know in many cases, okay? When the kid turns 18, they're gonna go out and maybe look for their parents, okay? And they're gonna try, and now with the internet and with all the Google and all of the search engines that are present to find, you know, your parents, I'm a realist. The whole purpose of our child welfare system is to keep the kids safe until they are old enough to make some of their own decisions. And we all know that if the kid turns 17 or 18, they're going to do what they want to do. And that's just being a realist. But when they're 5 and 4 and 3 and 6, they can't make those decisions legally. So that's different. When a parent's rights are terminated, the statute says, and there shall be no reasonable efforts to have the kids be with their parent. Okay. Now, I was involved. I guess I'm sort of proud of this one. I've only argued once in front of the Michigan Supreme Court. I was the lawyer guardian ad litem over some kids, and the father's parental rights were terminated. And the issue was he going to be required to continue to pay child support? He had already been ordered to pay child support, and the judge said yes. Well, he didn't like that. He said, if I don't have my parental rights, why should I have to pay child support? It went all the way up to the Supreme Court. And this was the first time, and it was in 2010, this was the first time in eons when the Michigan Supreme Court was unanimous on their decision. And they said that just because your parental rights are involuntarily terminated, that doesn't mean that you don't have to continue child support. So if you're the foster parent, they can continue to pay child support, even if their rights are terminated, even though they don't have any rights to see the children. Parents don't like that, but that's the law. So again, you know, to do the best you can, and we keep the kids safe until they're old enough to you know, make some of their decisions.
And there was one more question that came in. Can we get a list of how to report an LGAL, like steps of what to do in each county?
Could you ask it one more time, please?
Is there a list of how to report an LGAL, like what steps they should do in each county?
I don't know. I don't know anything about the other counties other than Oakland, because that's the only. I practice in Genesee too, but I'm not the lawyer guardian ad litem. I've been retained to represent parents there. I don't know, first of all, if there are any written policies in the county, and how you get them. I don't know. I guess one of the things you could do is on every case, there is an assistant prosecutor or an attorney general. And if you ask the foster care worker for their name and telephone number, they can talk to you. Because first of all, if you're represented by a lawyer, they can't talk to you without that lawyer's consent. We have a what we call a canon of ethics. I can't talk to an individual who's already represented by a lawyer. It's not something that I can do or any lawyer can do. But the prosecutor, I'm sure if they know of any policies or anything like that, they can tell you. I mean, they're in the court building all the time, because all the county prosecutors' offices are right in the same area as the courts. So they're there all the time. But to answer the question, I don't know. I don't know if they've actually written policies. I guess the best first step, if you have concerns about your lawyer guardian ad litem, I guess the first concern is approach that lawyer guardian ad litem and say, I have an issue. I have a question. Can you answer this for me? Can you help me? Why are you doing this or not doing this? And if the lawyer guardian ad litem takes a personal affront to it, then tough. You know, you are the ones taking care of the kids. And you have a right to ask questions. If the lawyer guardian ad litem is not answering your questions to your satisfaction, then I would go to a foster care worker and say, hey, you know what? I've got these issues and we got a problem here. The foster care worker will then go to their supervisor or go to the DHHS worker who has overall care and custody of the kids. And then they can start raising issues. And believe me, as unbashful as I am, they aren't bashful either. I am sure that at the DHH office in Oakland County and probably in some of the foster care agencies, they probably have a picture of me and they throw darts. My job isn't to be their friend all the time, especially if I represent a parent. I take it very seriously, whoever I represent. So, but you have a right to your questions being answered. And if the lawyer guardian ad litem has never seen the kids and is representing to the court that he or she has, then he or she is committing a fraud on the court. And that's a no-no. That's a big no-no. So that's how you do the best you can and you make contact. There are people you can talk to. So I hope in conclusion that something that I said was to the point. The answer that the guy on the shore said to the two people on the boat was pretty useless. I've given you the law in the written documents. Again, to non-lawyers, you may think it's legal mumbo jumbo. And that's how I think when a psychologist testifies in court. I think a lot of it is psychological mumbo jumbo. And that's, my job is to look at their testimony critically. And I look at the testimony of the foster care workers critically to determine whether or not they're doing their job, because they have a job too. And none of it's easy. None of it's easy. Again, this is my own personal thought. We have a lot of DHHS workers and we have a lot of foster care workers who are coming out of school and they don't have kids. And you can have all the theoretical knowledge that you may have gotten from your classes, but until you've had a child, it's a different world. And not every child is the same. Not every parent is the same. And not every foster parent is the same. And what I find sometimes troubling is that the workers who are just coming out of school are expecting the gold standard for the parents. And we don't live in a gold standard. We used to say the Cosby family, but we don't say that anymore, I guess, because of what took place. But we wish that every family had two parents. We wish every family, had computers in their houses for the kids so that when they're doing their schoolwork, they could do computers. But it's not true. We know that's not true. The law doesn't say they have to be perfect parents. The law says they have to be parents who provide for safety, provide food, education, medical care, a house free from illegal drugs, a house free from alcohol that impinges on the ability of a parent to take care of their kids. But I've never seen anything in any of the statutes or court rule or cases that says the parent has to be perfect. Because if that was the case, we would all be in the system, because none of us are perfect. And for you foster parents that have teenage kids living with you, God bless you, because once they turn 12, 13, 14, 15, the whole world changes. You are the stupidest person around. You don't know anything. You are unfair because their friends' parents allow them to hold a gun or, something ridiculous like that. And, as my son said to me when he was a teenager, he said, your hair's getting gray. And I go, guess why? It's a fact of life. So I want, on my behalf, I don't know any of the foster parents here. I don't recognize if you have been a foster parent on my case and I don't remember you. That's because I've been doing it so many years that sometimes I don't remember names. Sometimes I usually remember faces. On behalf of all of the lawyer guardian ad litem, all the judges and referees and everybody else in the system, want to thank you as foster parents, because without you, the system couldn't work. Obviously, they always look for relatives to be the foster parents because you want the kids in the most family-like setting. And if the kids have relatives, that's best. If that doesn't exist, then we need foster parents to take care of the kids. I don't want, quite frankly, I don't like when my clients are placed at Vista Maria or at Methodist or any of those places. I'd rather them be in a family-like setting. Those places are okay, they're safe, but they're not in a family-like setting. So thank you for your hard work. And hopefully the people that you have as lawyer guardian ad litems will be responsive to you, will be polite to you, will see that's another one of my bugaboos right now. People are so angry at everybody. They call names, they treat people like they're less than human beings. And maybe it's because of my age. I just don't understand it. So there is no reason that anybody has to be derogatory with anybody. And I hear it. I mean, I hear that, these people said this and they said that. There's no reason for that, and if it's done in front of the kids, then it's really a problem. So sometimes I like to do these programs because then I can pontificate on how I feel about things in life. You can accept it or you can throw it away, which is okay by me too, but I get it off my chest. These kids are so vulnerable. They're the vulnerable ones. That's, when with this pandemic, they said I was vulnerable, but the kids are so vulnerable. They really are. They didn't do anything to cause their removal from their parents, and they love their parents. I mean, how many cases do we get, when the termination hearing is, and they've met with the court psychologist and they say, I love my mom and dad. The parents could have done the worst things to them. They love their mom and dad. And then here's somebody making a decision that your father and mother aren't able to parent you anymore. Tough things that kids go through in life. This is a real tough. It's interesting. I was a hospital trainee when I did the health law, and when I got into doing this, it was a rude awakening for me. I didn't know this stuff existed. I didn't know there was abuse and neglect. I grew up in a home where all I had to do was see my mother's and father's face, and I knew I was in trouble. There was no physical discipline. I just knew it. I goofed up and I was going to get punished. So, but unfortunately there are homes where, I wasn't in a home with drugs. I wasn't in a home with alcohol. So, I mean, it's these kids nowadays are facing a lot of problems, and God bless them. Hopefully we try to save them all. I think we do a pretty good job. So, any other questions or complaints about LGALs? And they're not GALs. They're LGALs.
LGALs.
Yes, they are.
This
Anything
was
else?
well, so far, no other questions. We are definitely over our time, but it was such good information. So thank you so much for taking the time out. This is for sure something so different than we're used to even presenting on. Thank you, Jackie, for setting all of this up, our navigator, Jackie Gant. You are an incredible human being for coming up with this topic that obviously a lot of people wanted to hear. This is our highest now turnout for a training. So this is exciting.
Thank you.
And you will get this presentation as well as all of the reference documents that we're talking about today, as well as your certificate. You'll get an email that will send you to a Google Drive where you can access all of that information. So yes, your certificates will be emailed to you. So make sure that you signed in, or at least you put your name in the chat box so that we can find you. So if you did not send us your email, you need to click the link so that we can get your information. So again, thank you so much for coming and presenting to us. We really appreciate it.
My pleasure.
I'm gonna pass it over to Shireen to finish us out.
Yes, absolutely. Thanks again to Jackie Gant, who was able to arrange this for us. Thanks again to Mr. Carnes for all the information and being able to present to us. And so for all those that have stayed with us, we have some giveaways. And we just want to say, that's our way of saying thank you for joining us and that we appreciate you. What I am going to do now is to actually show the wheel so we can see who wins. We are giving away 3 gas cards. So that is pretty awesome if I do say so myself. Give me just a second. I needed to do something as far as my share was concerned. I apologize. That was fast. Okay.
Gas cards are very valuable right now with gas at $4 a gallon.
Exactly.
It'll come back down though. It's like everything else.
Okay, are you ready, ladies and gentlemen? Let's go. Our first winner is Ebony Graver. Awesome, Ebony Graver. And Ebony, you will receive an email on questioning how you would like that delivered to you. So thank you so much. And we have our next one after Miss Graver will be Pragmat Patel. You are our second winner. Thank you so much. And our last winner will be Katie. Our last winner is Katie Talon. Thank you so much for everybody. Like I said, you will receive that email about how you would like it delivered. I hope we answered all of your questions. And thanks again for everybody coming today. The Tri-County Coalition really appreciates having you all. And we will continue to have these trainings. And again, thanks. I can't thank you all enough. And for those that also helped facilitate and make this training possible. Everybody have a fantastic weekend.
Shireen,
And
can I
will
ask
be
you?
you will be getting a 2-hour certificate for the training. It won't be an hour and a half. It'll be listed as a 2-hour certificate.
Thank you,
Absolutely, 2
Shauna.
hours.
Shireen, I have a question. What
Yes,
is that
ma'am.
program that you just did? Because I want to do when I have a Zoom conference.
Oh, yeah, it's called Name Will. If you put that in your Google search, it'll come right up.
Name Wheel. Thank you.
You're welcome, no problem.
That's pretty
Really
cool.
easy to use.
Yes,
Great.
very easy.
Can I ask a question?
Yes, please.
Is it Ebony Graver or Ebony Graves?
I'm sorry,
Probably Ebony Graves.
it's probably Ebony Graves, who might have made a typo, so.
Thank you,
Yes,
Elliot.
there's an Ebony Graver in the group. Announce yourself now.
Elliot, this is Jackie Gant. Thank you very much for doing this.
Well, you're
Yes,
welcome.
thank you.
You're welcome.
Yes, thank you, everybody.
Have a good one, everybody.
Thank you.
Thank
Take
you.
care.
Thank you.